Hi, good morning. What we're doing now is we're just kind of review some information that I know some people are mulling over due to the issues that we have with the COVID-19 virus. A lot of those questions are going to be pertaining to what happens with the time sharing issues, what happens with the child support issues, and what happens with complying with those court orders and how that's going to be moving forward. So I just want to kind of leave it open for questions because I know there's going to be some specific issues that you guys are going to have some interest in. That's going to be a little bit catered to your case. And then I'll try to answer questions as best as I can or gear you or guide you in the right direction so you can have some feedback and some guidance on what to do. So I'm going to see if we have any questions at this point. There are administrative orders that are going to be available to pretty much every circuit. So if your divorce or your paternity case was in Orange County, you can Google or you can type in Circuit 9 Administrative Order COVID-19, and then you guys will probably be able to access that order. What it is the judges are providing directions on what they expect, and they also provide you consequences on some of the issues that we are encountering specific to the orders as it relates to family law. We're going to see what we have. I'm going to double check. I'm just going to see if there are any issues with the mics. And also any questions. Anybody have any questions? I know there's just a few people on here. Does anybody have any questions about how to answer or access the administrative code or any of that nature? If you are not from the local area, if you have a divorce or an order that's out of state, there's going to be a little bit different type of feedback that we would have to give to you. Of course, you always have the option of contacting or calling the office, setting up consultations. What I personally do is if it's just a few questions, if it's less than 15 or 20 minutes, I don't charge for that. That's not fair to do that. But if it's something that's more intensive, we look at the hourly rate. And then obviously, if there's something that needs to get a legal person involved, then we'll review having you guys or reviewing that information to get you on board. So I'm going to apologize because I'm not sure what I'm doing here as far as seeing if there are any questions coming up because I'm not able to see a lot on the Q&A. There he is.
That's okay. So we got one right here. It says, what is happening with back child support owed? And it comes from state.
Oh, can you clarify whether they mean Department of Revenue or is it there's no state of Florida involved?
No, do you mean Department or of Revenue? Yes, I believe so.
Okay. The person who's paying, the payor, is still required to pay. Now, if there are issues or if there's something that's happening where they can't afford, like we are aware that people are being furloughed, we are aware that people have lost their jobs, we understand that unemployment is not responsive, unfortunately. We also understand that a lot of people are not getting the stimulus check as well either. That person's got it, the payer has to notify the court. So there has to be a motion filed to at least let the court know that they are experiencing some significant issues. There's a couple of options they can try. They're required to give the recipient. So if you're receiving the child support, you should receive notice of this as well. They're required to tell you what's going on with your case. But if the person is unable to pay, then again, they have to do a motion to the court. In more intensive situations, they would have to do what we call petition for modification if there's going to be a permanent change that they weren't aware of in the initial situation, and they'll have to recalculate that. It does not make the arrearage or the retroactive, whatever you have in place, that does not go away. That person owes that money, period. Now, it may adjust the payment plan over time of what they owe, or it may have them abate it temporarily, but it's not going to go away. They're going to have to pay that off. Let me know if that answers your question. Did that answer her question?
Knew how'd that work. Did that answer? You can always respond in the chat or the Q&A.
There's a chat? See if I gotta learn how to use
this. Yeah, they say yes, it does. Thanks. Yes, the Q&A is it. For some reason, they have a chat and a Q&A. So,
Oh, okay.
but yes, they said yes, it does absolutely.
Okay.
One thing that we touched about on the Facebook event was talking about how COVID-19 has changed things, how it's altered things, how it's altered everything. So, what are some changes that you've seen in terms of that, like with
Well,
family law?
I think a lot of people, because we have seen this global kind of shift where everything's been put on hold, what we really have to emphasize and that the court system is not on hold. Just because you're not physically allowed to go to court, all of these cases are still progressing. The only thing that I'm noticing that things have been postponed are your evidentiary type things. So if you have a trial or if you have to have a hearing where you have to show evidence to a judge, those types of things are being postponed. Everything else is doing exactly what we're doing right now. We're doing Zoom hearings. So, and also if there's an active order in place, the judges have addressed it in each of the circuits. I actually pulled Circuit 5, which is 5 counties, Lake, Sumter, Citrus, and a few other counties. I can't remember the other two. The 18th Circuit, which is Seminole and Brevard County, Orange and Osceola County, they all have administrative orders in place. It says you got to follow the orders. They will understand. However, if we encounter some issues, they're going to be able to consider that if it's reasonable. But people who are, don't really have a good reason why they're not following the court order, it's going to be looked at very closely. That's why it's really important to at least consult somebody, especially if you really think that something has to change on a temporary basis. Then you really need to work out with the other parent, or you need to talk to an attorney to make sure you're not going to get in trouble for not complying with that court order.
We've got another question here. So another question is from Nui is, what about his stimulus payment? Will I receive that because he's behind? So in case someone's behind.
I don't think they're garnishing that. I didn't see where it was directly addressed, since the stimulus is directly, from the federal government. They really haven't provided us information of exactly whether or not they're going to garnish. Now, normally, if you do owe arrearage and you're back or you're not paying, they will garnish it and they will send it to the person who's supposed to receive it. So I'm not going to say they are going to do it because I don't have that stimulus package in front of me to verify that, yes, the rules still comply. If a person's in arrearage, that money goes to the person that should receive it. However, it's likely that, yes, that money should be garnished and should be sent to the recipient who is owed that money. That's correct.
Excellent. Let's see, any more questions in the chat, guys? Make sure you post them in the chat. And then we talked about, of course, what are some changes that you've seen? What are some recommendations? You're talking about getting in soon, getting in as quick as you can because the courts are there. Things are still happening, even though it seems like they're not. It seems like things are on pause, but they're not.
Right. It's always important to keep the court system informed. I know a lot of you who have been through this process already know that you're required to update the court with your address. Just think of it that way. If something large has changed in your life and it's going to impact how you guys are complying with the current order in place, whether it's child support, time sharing, even alimony, that's another big component, or equitable distribution. If the parties recently divorced and they're still splitting their assets, and everybody forgets this, there's a lot of marital debt that has to be paid. So that kind of stuff really needs to be addressed, because not only is it you and the court order process and you not being in violation or contempt, it's also those third-party creditors that are going to be involved that you want to make sure that you're not going to get any more trouble or you're not going to have some massive problems regarding those particular debts. And then the assets, of course, we know, fortunately, our 401k counts are down. There's people who have active qualified domestic relations orders. In other words, they're splitting those accounts, and what they originally thought it was is no longer that amount. So that information needs to be shared with the parties in the case and, of course, updated as well. So it is important. Yeah, don't sit on anything. I cannot emphasize that enough. Don't sit.
Right.
You need to make sure that stuff is addressed.
And then we have we have another one here. We have so this one's a little bit of a longer one, and it seems to be it's a big one. So let me finish it off, and then if we want to segment it into two parts, we can. So it is, what can we do for a client that is not getting their court-ordered time sharing because the other parent is withholding kids for 2 months due to COVID-19? They say we filed an expedited contempt motion and served her with that and the administrative order saying the time sharing order should be followed, but she still refuses because she knows we can't get a hearing on a contempt right now. Is there anything else we can do?
That's a tough one. If there are any other issues that are involved that would meet the criteria, I'm assuming this person has a lawyer because they're saying we. If there are any other issues involved specifically that would rise to the level of what we call a verified emergency motion, something of that nature, because not only is the time sharing ordered, I'm assuming it's the mother that's not complying with the order. It even says if it's an Orange County case, and actually they all mirror Orange, Brevard, all these counties all mirrored each other on these administrative orders. They're required to keep you up to date. You know, it is absolutely inappropriate, and it is not going to be looked on in a favorable light if somebody is acting foolish and they are not at least telling the dad how his kids are doing. Review the option of a verified emergency motion. Those are the only ones that are going to be immediately heard during this time frame. The lawyer can still set a Zoom hearing almost in all the counties in our Central Florida area. You don't have to wait for the courthouse to reopen. The hearing could be set and the lawyer just has to kind of get involved with the other party. It's the notice situation to make sure that they're aware that they have to appear by Zoom as well. But I've done these hearings as well. These motions, I've gone on the other side. I've had a hearing set and we present information by Zoom, because once you have the court order in place that says, hey, you're on notice and you don't comply with this, things are going to they're not going to look good for that other parent. You just have to be a little patient. But if you're not getting any information, blow up that lawyer that you have, because it's time for them to get their butt in gear and get something done for you. Hopefully it's not one of us. I don't think it's any of us. They're like, thanks, Marsha. Anyway, yeah, that's important.
And then we had in the chat, any kind of motion. Did you answer this one already? For in the chat, I believe any kind of motion he would file it should show up online in my cases file, correct?
I'm sorry, what does show up on his clerk docket on the motions that are filed?
If you could, either in the chat, clarify that it's well, it's the chat that should be on the side of the meeting there on the right hand side.
Okay. That's correct. All of as long as your motion has been filed with the clerk, then it'll appear on what we call the docket. So when you go on the website, of course, lawyers, we sign in, we can kind of see a little bit more, but the public can sign in as well. You should be able to see your motion. Do you know how to use e-file, or did somebody assist you with e-file? Because obviously you physically can't go to the clerk's office right now. Let's see if that person can answer that question.
Yep. You can. They said I go to the website.
Okay.
So My Orange Clerk, I'm thinking, might be the website.
Yeah, that's definitely the website. And you don't see your motion yet?
And sign in and see everything.
Has the motion been filed? A motion for enforcement or contempt? Is it ringing any bells? Oh, you're wondering if the other party did. If they did, it should show up. It usually takes about 1 to 2 business days for the e-file system, if that's what they're using, to get it to show up on your docket. But yes, if anything's actually filed in your case, it should show up in that little clerk docket that you're looking at on Orange Clerk. If you don't see anything, I doubt he's filed anything yet. You can do you feel comfortable reaching out? You can ask her, just send in an email or a text message. What's the status? And what's he going to update you?
Absolutely.
Yeah, unless there's, I don't want you guys doing that if there's domestic violence, if there's any concerns for safety, but if there's no limits on the communication, reach out and see what he says as far as what he's doing and how he's going to catch up with those payments. You don't have to wait for a lawyer on that one. Oh. Did he lose his job? I don't know if she can say that. If he has money and he's not paying, it ain't gonna look good for him. Oh. Is there any reason why you're not communicating with him? She's typing. They're waiting for the answer.
And of course, if you guys have any other questions, go ahead and put them in the Q&A. We can get them there directly.
Wow. And now's not the time not to be supporting your kids, especially if you have the resources.
I think this is the time when things are getting tight money-wise, you know, especially right now.
Yeah, it is. Definitely understand that.
You know, so, but if you've got the money, you know,
Yeah.
that's the responsibility.
Yeah, if the one thing we do emphasize to individuals is if you have the money and you just don't want to pay it, that's where you're going to see some jail time. I think that you definitely don't want to go that route. I know you get upset, you want to show your butt a little bit. That's just not the route to do it.
Right.
So you got the money or you have the income or an asset that you can tap into, and the court sees that it's reasonable for you to do that, and you're like, nah, I don't want to do it. It's not going to go. It's not going to go well for that person. That's one of the only areas in civil contempt where a judge has the option of sending you to jail. Yes, yes, something can be done. If he truly doesn't have the ability to pay, then it'll be tacked on to more arrearage that he's going to owe. If he does have the ability to pay and or he has a pocket of money or an asset that he can access in order to get caught up or make sure that he's on board with that child support, it's not going to look good for him. Depending on what information is provided and what judge is on the bench, there's going to be a consequence for that action. And if this is a Department of Revenue case, I am aware some of the jurisdictions are telling these guys to freeze, don't issue writs. The writs are the ones where the state of Florida has ordered this person to pay child support, and a writ is when it's issued, everybody knows, when they pick up they didn't pay their child support, they actually get picked up and taken to jail. Their driver's license is suspended and all that kind of stuff. There is a temporary stay on some counties. They don't want Department of Revenue to issue these writs so these people are picked up and taken to jail. They do want people to communicate with the court and let them know what's going on with their cases, though. Okay. There's a high likelihood that obviously the state of Florida tracks it. That's going to be in their system. They will file a motion for contempt and enforcement. They may or may not issue the writ for that person to be picked up or suspend his driver's license because, like I said, the courts are asking them not to do that. Not all courts, just a few of the jurisdictions, until we're kind of normalized and there's no reason for him not to have full employment in order to pay his obligation that he owes you. But yes, they're definitely gonna follow through on it. The state don't play. They do not play. They're going to find a way to look at the resources, and the state of Florida will look at garnishing that stimulus money if they have the right rules in place where they can do that. Ah, you're very welcome. I'm glad I could help. It's a tough situation, though.
This is why we do this. This is why we do this. And, you know, what I always say about tough situations, you're never alone in them. You're never alone.
No.
So don't feel alone, reach out to us for help. That's the key,
That is correct. That is correct. And we'll be doing some more. I think that family law is one of the big areas that people are going to have some questions with. I think a lot of people kind of narrow their focus on child support, but there's some contractual obligations that are happening as well that everyone needs to be up to date on, just to make sure that they're not getting dinged, because eventually you're going to get called up. Just to let you guys know, it's not going to oh, no worries. we understand this, it doesn't work that way. Eventually you're going to get called up and somebody's going to be required to give an explanation, and it needs to be reasonable. So if someone lost their job, obviously that's a very reasonable explanation. Or if someone decided that they were in a high risk situation and it was not feasible for them to work because they may contract the illness, obviously those are reasonable issues. But somebody taking advantage of the COVID-19 or using that as their excuse, really not having a good reasonable explanation, yeah, it's not going to reflect well on that. So just use your head is just a good way to put it. Just use your head on these things.
That's one thing I was going to ask was, what are some of your predictions with what's going to be in the next, couple months, family law wise, with this COVID-19 and everything going on right now? Are you seeing any trends? Are you seeing any, or do you have any guesstimations about what things might be and how that might affect what's going on?
Well, I think we're kind of saying this jokingly. However, we do suspect that we're going to see a spike in our curve, unfortunately, for divorces or paternity actions that are going to be taken. I do see a lot of modifications that'll probably be filed, because a lot of these industries that were really successful, your retail industries, your restaurant industries, where one of the partners that are no longer together in the relationship is used to providing substantial financial support, they're no longer going to be able to do that. There are a lot of industries that are not going to be able to reopen. They're literally going to have to start from scratch. So we expect that we're going to see a lot of what we call petitions for modification, simply because those resources are no longer there. No fault of their own. They were forced to shut down. And unfortunately, a lot of this is our alimony cases, our equitable distribution pieces where they're on like a payment plan, that have a little bit more of an estate during the divorce. And even, ongoing child support. If a person's normally making $100,000 to $200,000 a year, that's no longer an option for them to pay the amounts that they have now, because those resources are no longer there. So, and those are the ones they cannot wait, because it doesn't go away. It's going to keep accruing and it's going to keep adding up. So it's really important to file that petition. And the physical courthouse doesn't have to be open. You can go through an attorney. You can sign up for e-file, e-portal. If you go to the Orange County Clerk's website, they all have that self-help stuff as well. Whatever you need to do, because the date that you file that petition is the date that's going to the court will go back to say, hey, this person didn't have the income. They're no longer going to make that type of income. So it's really important that we adjust these numbers accordingly. But don't sit on this.
Yes. Do you find sometimes people do wait and it's not good?
It's not good, because in some cases where you have judgments or orders for those equitable distribution or alimony or any of those things, there's this thing that kicks in called statutory interest. That should make you panic, because you're going, man, you have a couple $1,000s that you may owe that ex-spouse, that thing jacks up to $5,000 because you sat on it for 2 or 3 years. And then the statutory interest fluctuates. 1 year it's 5%, 1 year is 8%. I've seen an 8% year. I mean, that caused me stress right there. So you don't want to get yourself in a situation. In some cases in family law, you can get these orders reduced to judgments. And now these people are going to be garnishing your income. So it is never good to put blinders on or hope that other person's going to really understand how things are going. You always want to keep the court updated. Just let them know what's going on. The judges are very reasonable. They know exactly what's going on. They'll help you get in a better situation so you're not, in panic zone.
Excellent.
That would be tough.
Yes.
Yeah, it's pretty rough. And we are seeing a lot of those modifications. We already have people calling in. They're prepping. They're getting themselves ready because they know there's just no way. A lot of restaurant owners, even now that they're opening, they're only allowed 25% capacity. So
absolutely. How successful, it's got to be very difficult to be successful at that with those limitations,
Mm-hmm.
Yes.
Yeah, and they have more. Of course, they can get those PPP loans. Hopefully, majority of it doesn't have to be paid back. But then again, as we kick into the end of 2020, these guys are going to start getting hit again in 2021. So even though you may not be, it's impacted now, it's really important to prep yourself because you may have to look at changing some of these terms in these orders. But you have to file a petition. You know, you can't just say, hey, let's just change. If the person agrees, there are ways you can do what we call joint stipulation or agreements. I just know that even though everyone says they're in a great relationship and things are going to be so great, a lot of times there is still some friction, especially when you're dealing with finances. So my suggestion is have an attorney involved or a mediation, something involved where you can at least get something started. If that person or your ex-partner is willing to do these agreements, you need to make sure the format is correct as well. And I strongly suggest an attorney involved. It's worth the investment, whether it's 1 or 2 hours of a lawyer just to read over it, or 2 or 3 hours or 4 hours for the lawyer to write it for you. And then you guys can sign it and the lawyer can make sure it's filed. And a lot of those have to be ratified into a court order as well. So just definitely make that time and make sure you do that research on that as well.
All right, excellent.
That's good. No other questions.
Any other questions, guys, for today? Any other questions? We do want to say that we do these webinars every single Tuesday at 11 o'clock a.m. So please, reach out to us if you have certain subjects you'd like to see us do in the future, and thank you, Marsha, for coming on. If you want to give us a little outro, give us a little bit of the overview of what we talked about, any big reminders that you want them to take with them.
Yeah, the big reminders, when at all possible, follow that court order. That's your major thing to do. You never want to be in a position where a judge is looking at you going, you didn't do what you were told, you didn't do what your court ordered. There's no option for them except to find you in contempt, or they sanction you, which means you're going to get punished. It could be money, it could be make up time sharing. One of the things that I did want to touch on was the person whose the mother of the child is not complying with the court order time sharing, and we have that admin order in place. He should be able to get that make-up time sharing. So the attorney, I'm sure that's working with him, has addressed that with him, but it's right there in the administrative order. If you act up, we're going to make sure to fix it. The judges aren't playing during this. So it's really important to follow these orders. If you are in that situation, it's extremely important not to sit on it. So definitely go online, look at the self-help stuff, or get into contact with an attorney, call our office, and we'll see what we can do to help you. So those are the main things. Don't sit and follow the order. All right.
Awesome. Thank you guys for coming on. And Marsha, thank you for being here. And we'll see you guys next Tuesday.
Bye. Have a great afternoon.
Bye.